And away we go. Hello, everybody. Great to see so many, familiar names in the chat. Not so many, but a few so far. Everybody's jumping in. Great to be here. Really, I'm excited about tonight's topic. I don't like to mess around and don't like to waste time when we get started, so let's jump right in. What to expect to discuss when you create an estate plan. I like this topic because for a couple of reasons. One, I get to share with you from the lawyer's perspective what we need to know, what we need to ask. Also, I think as we go through this, it should give you some kind of comfort level, like hey, this should not be such a painful process. These questions that this lawyer's asking me, they actually kind of sounds like fun process to go through. So that's what we're going to do. I'm going to go through 4 parts here. I think we need to spend a moment or two talking about why people create an estate plan. But then I'm going to jump right in part 2 of this live stream, or the questions you can expect to be asked. And then 3, we'll go through a case study, go through an example of a couple and their situation and why they answered questions a certain way. And then finally, we'll talk at the end about how to get started if you feel like you need to get this in place. So good to see everybody on the chat. Typical rules: if you have some questions, some comments, something positive to add, maybe an experience you'd like to share, we can all learn from it. That's the whole idea behind doing the live stream, is to get some live, positive, active participation. So feel free to throw those questions, comments, and experiences into the chat. What I'll do, I've got some information I want to present, and then we'll move on to the chat and we'll go through those one by one. And of course, we want to keep those positive and constructive. So, all right. So first part here is why people create an estate plan. And so I can speak to that because that's one of the questions sometimes I ask people. Why are you talking to me? And people create that estate plan for a variety of different reasons, some of which are general and some of which are very specific. So some people just kind of feel naked without one. Paul, we got nothing. Paul, we got nothing in place. Paul, we know that if something were to happen to us, we have nothing and it could be a mess. So some people have that incentive to get their estate plan in order because they kind of feel naked without one. Other people, they have a fear, and that fear could be any one of a number of things, but they want to take care of that fear. They want to eliminate that fear by putting an estate plan in place. And that fear could be the fear of leaving their family with just a big mess on their hands, or that fear could be that maybe one of their children or one of their heirs may blow their inheritance, and that inheritance may do that particular individual more harm than good. Other people feel that, when they pass away, the wrong people might be in charge, and those wrong people might muscle their way into some bad decisions. Other people fear that unless they do something, their estate may pay some unnecessary tax, income tax, capital gains tax, state or federal estate tax. Other people fear that, their surviving spouse might remarry, might get into a new relationship, and they want to make sure that the children are protected from the surviving spouse, either intentionally or unintentionally making a mistake or doing something that was not part of the overall plan. Some people they'll say, Paul, my son-in-law has already told me he says when I pass away, he's going to contest everything that I've done. So some people fear that. Don't see that a whole lot, or don't see people saying that a lot. Obviously, you see the estate contest from time to time. But if there is, on that note of fearing things, if there's what I want to say as the estate attorney is, if there's something that you fear might happen, and the lawyer doesn't ask you about it, it's really important that you kind of actively communicate that fear or that concern, so that it can be addressed by either some action or some explanation, or at least a discussion. So whether that's you fear an estate contest, or you fear some kind of probate matter, some people, we have a lot of conversations where people start the conversation with, I'm worried that I'm going to lose everything if I go into a nursing home. And so that's the fear they come to the estate attorney with. Now, if they're sitting there with a $5 million IRA, we're not going to take all that stuff out of their name. We're not going to try to get them to, and then I'm kind of getting you to the punchline quickly, not going to try to get them to where they have less than $2,000 in their name. And so, but even if we're not going to take any legal action about their fear, at least if they communicate their fear that they're going to lose everything if they go into a nursing home, even if they're sitting on a $5 million IRA, a $2 million house, and other, assets, at least we can have a conversation to, to at least eliminate that fear, maybe by having a discussion about how they're just not a potential future Medicaid recipient. So, and some people fear taxes. So if you have a fear and the attorney doesn't ask you about it, you need to communicate that fear. It's kind of on you. The attorney can't help you if he doesn't know your concerns. Some people don't have a fear. Just got off a Zoom call with a couple from Maryland, by the way. And the wife was just, we want things to be simple. I don't think she feared anything. She just had this desire for that, when the first spouse dies and when the surviving spouse dies, they just they don't have to go through a bunch of legal mumbo jumbo. So that was another kind of motivating factor for them. They just wanted to be simple. Also with the couple was saying, well, maybe we can set this up to be perhaps even kind of multi-generational to help our children and then maybe help our grandchildren down the road. So again, not a fear that they had, but a desire. And, some people are motivated by making sure that someone gets acknowledged. I want to leave $10,000 to this person. They've been good to me. Some people have a specific idea about the distribution schedule. I don't want to leave it to just my children equally. I want to leave 40% to this person, 15% to this person, 10% to this person, or what have you. So anyway, that's a pretty good idea of some of the reasons people create an estate plan. If you feel like I missed something, or there's a fear that you have, or a goal you'd like to accomplish, or maybe somebody else has told you about a goal they wanted to accomplish, or maybe a concern that they had that would have motivated people to take some action, throw that into the comment or into the chat. We'll all benefit from it. Okay, so now let's get into Aaron. How dare you miss the start? You need to be punctual like the others. It's a joke. No kidding. Just kidding. So 6:30 Central, 7:30 Eastern is the typical start time. So anyway, you can check the post that I have on the community tab on my channel to see other ones that are scheduled for this week and even into next week. By the way, I finally got the guts to post one about all of the IRA after death required minimum distribution rules. We'll have that one a week from tonight, just in case you're interested. So tough topic. So anyway, going back to the questions you can be expected to answer from an estate lawyer when you set up your estate plan. A couple of items before we get into what are some of the direct questions an attorney may ask you. I'm going to assume that you are married and you and your spouse are being asked these questions by an attorney. If you're not married, you can really kind of figure out what those questions might be. If you're not married, it's kind of an easier situation if you're not married. But if you are married and a couple is going through this together, then that's the situation that we're going to address here in this live stream as to what questions you can expect to be asked. Okay, I've got about 15 questions that you can expect to be asked, but I've got to tell you, your answers to a question may create a whole new series of questions. So there's at least 15 that I know you're going to be asked. But as we go through it, you'll see where, if I ask you question number 4 and you answer it a certain way, boy, we got to go down, path of question number 4 that may cause there to be another 10 or 15 questions before we get to question number 5. So let's just jump right in. All right. Not really a question, number 1 is, but more, I've talked to a lot of attorneys in my business over the last 30 years. I've mentored many. I've been online with many. And so I know the business practices of many. Now, some lawyers, before you even have the conversation with them, some lawyers will give you, I call it homework. Hey, will you fill out this 4-page, 10-page, 2-page, 18-page questionnaire? And that will make our conversation easier because you'll have answered all of the questions in the questionnaire. I'm not a big fan of that at all, because maybe it's because when I went to school, I didn't like homework and I did the minimum that was necessary. Other lawyers are comfortable. Hey, fill out this questionnaire. Once you fill it out, then we'll talk. And then there's a percentage of those that will just never fill it out because they don't want to do their homework. I can't really blame them. And then there'll be a percentage who will do the homework. And then there's the others who will just do their homework over the top and get an A plus 100% for their homework. But because estate planning is an area where people tend to procrastinate for obvious reasons, you have to think about dying and you're going to have to make some decisions and you're probably going to incur an attorney expense. For all of those reasons, people tend to, not that they're valid reasons, people do tend to procrastinate with estate planning. And if a lawyer gives their prospective client homework to do, it just gives that prospective client another reason to procrastinate. So I'm not knocking the lawyers who give their clients homework, and it works out great when the clients fill it out. And it does make for a less discovery that's necessary in the initial part of the actual conversation with the attorney. So some will ask for homework, some will not. I'm just on the side of not asking for homework. We'll get what we need in the conversation, or if we need some data once we get started, we'll get that data, how all of the children's names are spelled and all that kind of thing after, we go through all the substantive stuff. All right, so let's roll into that. That was what I call question number one, is some lawyers will say, please do some homework. Number two is who's in your family tree? I'm not asking you if you have kids just because I'm trying to make some conversation with you. I need to know, okay, do you have children? How many children do you have? In fact, in those first conversations, I actually kind of draw out a family tree on my little pad here when I'm having a Zoom call with people around the country. And I find out their first names because I draw the family tree. So I need to know who's in your family. And what's your name? What's your spouse's name? What are your kids' names? Are your kids married? Do you have grandchildren? So for purposes of all the estate planning stuff we have to do, we have to know what your family tree looks like. So that's another question. What's your family tree look like? And there's a couple of other questions that estate attorneys need to know the answers to before we can get into the, who's going to inherit from you questions, which are important and which are coming up. So another question is, hey, what do you own? The reason that's important is because often as part of the estate planning process, things have to be titled a certain way, maybe titled in the name of a revocable living trust, or maybe beneficiary designations have to be set up a certain way to be consistent with all of your estate planning goals. So we need to know what you own. And, I often say, let's start with real estate. Do you own a home? Most people do. Do you own any other real estate? Yeah, we have some rental property, or have this commercial building, and is that rental property, or is that commercial building, is it owned in your name, or is it owned in an LLC, or do you own 100% of it, or do you own a part of it? Yeah, I own 25% of my parents' land. I own it with my 3 siblings. I own 25%. So the lawyer needs to know, what you own. Do you own, some people say, well, we also own a timeshare, and we own a business, and we have these LLCs, and we have at Fidelity or Schwab or Vanguard, we have $2 million. Oh, you have $2 million at Fidelity. Well, what kinds of accounts are those? Are those traditional IRAs or Roth IRAs? Are they brokerage accounts? Because all that matters. IRA accounts stay in your name. Brokerage accounts often get transferred to your living trust to avoid all the probate stuff. So really what you own, in fact, our law firm sends out uses some software that we do send to people once we get started, where they can fill out and they'll have that software forever. It's kind of we call it our online vault, where they can document what they own, all the estate planning documents that they sign get uploaded. Everything that their survivors might need is all on that one site, and they can change things from time to time, and we can add things to it as well. So really, what do you own is an important question for the attorney to ask. Also, the next question, I'll call it number 4, is what's your net worth? It seems to me, you guys can tell me in the chat whether you agree with me on this statement. Feel free to disagree. But it seems like the financial advisors out there, when they ask what do you own, their clients are a little bit reluctant to tell their financial advisor what they own. I think for fear that financial advisor may try to consolidate all of the client's accounts at one place. I get that. But, the estate attorney also needs to know what's the, if you add it all up, what's your net worth? All of your retirement accounts, your real estate, your business, your life insurance, any money in the bank, stocks, bonds, mutual funds, add it all up, what's it worth? We need to know that number. Number one, because it's just good for us to know, so we can kind of do our samples in context. Okay, you have $3 million, you have 3 children. Yeah, each child is going to inherit about $1 million. Yes, the values will change over time, but at least it gives me an idea of kind of what we're looking at. But maybe even the more important reason we need to know what's your total net worth is it may have federal or state estate tax consequences. Usually doesn't have federal estate tax consequences because of our $13.61 million exemption. It's going to go up again next year. It's going to be cut in half the year after that. So some people will be subject to it. Most won't. But we need to know that net worth so that we can take the appropriate measures, even though that estate may not be subject to estate tax if you were to pass away tomorrow. It may be subject to estate tax if you pass away in 10 years or 20 years. So we need to know that to plan accordingly. All right. So that's kind of, to me, that's the lead up questions before we get to the meat of the conversation. Now it's time to make some decisions. So I like to tell people, whether it's a single person or a married couple, maybe it's just my style, but it seems to work, and it seems to get people to open up and really kind of enjoy the conversation that we have. But I always tell people I like to start at the end and then work our way back. So if I'm talking to a married couple, the question's going to be something like, because I like to start at the end and work my way back. And most couples, they're comfortable talking about the end. They may not be quite as comfortable talking about when one of them passes away and the surviving spouse potentially remarries. It's a little sensitive. So let's start with a question like, okay, let's say, and I usually preface it with, look, I like to start at the end and work our way back. And let me ask you this question, because it probably won't happen this way, but it helps us get where we need to get. So the question is, in the unlikely event that you both pass away, and then I'll say something like, well, and I realize that's probably not going to happen, that you're both going to pass away at the same time. It's much more likely that one of you will pass away and then the survivor of you will pass away maybe years later. But just for kicks and just so we can get this thing going, if in the unlikely event that you both passed away at the same time, how would you want everything to go? So for some reason that question just works, and they're able to pretty much just jump right out and answer it, particularly if it's a one marriage with children. It's not a blended family situation. So because if it is a blended family situation here, we're going to have to go down a different path and ask a bunch of more questions. But a lot of couples will say, well, we'd like everything to go to our children equally. We have 3 children. We'd like it to go 1/3 each. We have 2 children, 50-50. Some people, for whatever reason, there's no right or wrong here, but other people will say something different. Yeah, we'd like 40% to go to this one child, and then 30% to go to these other 2 children. The one child who we're leaving 40% to, they might say, well, that child has struggled, they're going to need a little bit more. Or they might say, these two that we're giving 30% to, we've given them a bunch of money during our lifetime. We haven't given anything to the one we're leaving 40% to, so we think we should leave that child 40%. So none of that is right or wrong. What's most important here is that you're making kind of good, informed decisions, taking into account all the different things that you need to take into account. All right, so then after that, okay, so we've gotten through the if you both pass away, and if it is, I'll call it a blended family. Maybe husband had 2 children and he divorced, or his wife died, and wife had 3 children and she divorced, or her husband died and then they got married, and so that one might be kind of a difficult question. If you both pass away, how do you want things to go? And so they might say, well, we just want everything we have to go to our 5 children equally. He has 2, she has 3. Let's just keep it simple, they say, and leave it to the 5 children equally. Others will say, well, if both spouses die at the same time, the husband's portion should go to his 2 children. The wife's portion should go to her 3 children. That's not leaving it to the 5 children equally. But if that's how they feel, that's okay. We got to make that happen. So that's one question. If after you both pass away, how do you want things to go? If you're not married, you'll just be asked that, okay, when you pass away, how do you want things to go? It's more of a, who do you want to benefit it? And I'm trying to figure out here, are there any other people? Are there grandchildren? Are there nieces and nephews? Is there a charity? Are there siblings that you feel like need or you'd like to leave them something from your estate? When I'm asking that, if something happens to both of you, how do you want things to go? I'm typically getting an answer equally to our children, or they have some unique distribution schedule that they'd like to have. So, all right. Then the next question. Okay, so yeah, you said you wanted to leave it to your 3 children. You were married once, you had 3 children. They're all adults now. Fantastic. Your kids are 24, 21, and 19. So my next question is, do you want to leave it to them outright, where they can do whatever they want to with it? You just leave it to them and no restrictions whatsoever? Or do you feel like maybe because where they are in life, their financial maturity or immaturity, looking at some of the financial decisions they've recently made, do you feel more comfortable leaving it to them in a way that it's doled out to them over time? And if we do that, we'll talk about what doled out over time means and what you feel is right. So some parents will say, our kids are adults, they're doing great. Let them have it. We don't need to have it. They don't need to have their inheritance managed for them. Let them have it. Great. They made an informed decision. Or they might say, you know what, I don't think they're ready, or I don't think one of them's ready. Most parents like to treat their children the same, so it's got to be a pretty difficult situation to say, well, this one child, they're not ready. I'm going to leave theirs in a trust. The other 2, they can do whatever they want to with it because they're mature. So parents don't like to do that, but for sometimes it's necessary. Most parents like to treat the children the same. They'll either leave it in trust for all of the children or not leave it in trust for them at all. By the way, there's this kind of hybrid leave it in trust, let them control it situation, which has to do with the making it, I call it divorce proof. Yes, you could leave it to a trust for them, but perhaps they would be their own trustee. So you're not restricting them. You're just leaving their inheritance to them in a trust to make it less likely that their inheritance will get mixed up with other assets that they have with their spouse. So if they inherit and then get divorced, they can keep their trust, and then they'll split the other assets that they've acquired with their spouse. Okay, so we've got to get through. We've gotten through the who do you want to inherit from you question after you both pass away. We've gotten through the do you leave it to them outright or in a trust? And again, your answers to that may cause us to go down a path creating many, many more questions. If you leave it to them in trust, lots and lots of questions about when would they be entitled to the principal? Would they be entitled to principal for their health, education, maintenance, and support? Would they be entitled to principal and stages at maybe age 30, they'd get a third, 40, a third, 50, a third? Would you like them instead to get maybe a monthly amount? You'd like them to get $4,000 a month until their inheritance runs out. If so, would you like that amount to be adjusted for inflation every year so they could get a little bit more until it runs out? So as you can see, there's lots of questions that you'd be asked if you don't want to dump an inheritance into the lap of someone because they may make some bad decisions. You want to prevent that from leaving it in trust for them. All right, next is, okay, so now we've determined who's going to inherit from you. Are they going to get it outright or in trust? Next is, okay, after you both pass away, who's going to be in charge of making decisions like whether your house gets sold, who's going to go to Fidelity or Schwab or Vanguard or wherever you have accounts, and who's going to be the person, you said you wanted to go 3 ways equally, but who's going to be that person? Maybe we'll call it an executor, maybe we'll call it a trustee. We haven't gotten that far yet. But who's going to be that person that will go make sure that everything does get split up in accordance with your wishes? If you're leaving it to 3 children, you have to name somebody who will be in charge if it's appropriate to sell your house, deal with your business, go round up your money from the various brokerage accounts and make sure it all gets divided up, pays your bills, pays any estate debts, and then divides up the money 3 ways. So get a lot of questions back when we ask that question. Well, should it be one of the children? Maybe it should. Maybe it should. It may be one of the adult responsible children, and we'll get the question back. Does it have to be one person? Can it be 2 or more? Can it be all of our children? And then usually there's a conversation where it could be 2 of your children, but many financial institutions won't accept an arrangement where they have to work with 2 people together. So it's better if you designate one. So there's some usually conversations around that when who's going to be in charge when you both pass away. That to me is I've gone through a bunch of questions, is my question number 7. Who's going to handle all of this when you pass away? Some people mistakenly believe that whoever they designate to handle this can change the distribution schedule. That is not true. So they have to, follow the wishes that you expressed in the appropriate legal documents. They don't get any financial benefit. They may get some compensation if you provide for that, or if the state law that handles this provides for some executor or trustee compensation. But other than that, they can't change your distribution schedule. Okay, so those are, and I'm trying to kind of be fast and use our time wisely. But that's a quick overview of the after you pass away, or a married couple after you both pass away, how things are going to be handled. Now we're going to back up a little bit to the married couple and ask them, let's talk about how you'd want to leave things to each other when one of you passes away, or when the first spouse to die. What happens? There's a bunch of different options and they're really unlimited, but for purposes of our live stream here, I'm gonna really break it down into 2 options as to how married people leave their estate to the other. Yes, when a married person dies, they can pretty much do whatever they want to with their half. So there's no limit. But most people want to provide somehow for their spouse, and then ultimately for the children if they have children. So the 2 options that we present with people, let's call them Mike and Carol. So I'll say, I usually make a joke and say, Mike, I'm going to knock you off first, because sometimes the men might be a little older, and longevity tables, women live longer than men. So I hear. So, and most men think they're going to die before their wife. So I'm like, Mike, I'm going to knock you off first, if that's okay, but it would work the same way, even if Carol passed away first. But Mike, if you pass away, you've got a couple of different ways you can leave your estate to Carol. And so I'd say, Mike, you told me you have a $5 million estate. Let's call it 2.5 each for Mike and Carol. Mike, if you pass away, Carol's going to still have her $2.5 million. But Mike, what are you going to do with your $2.5 million? Do you just want to leave it to Carol? That's simple and it's easy, and it's going to all be put into Carol's estate. And when she dies, maybe 20 years down the road, it'll all get a step up in basis, which is a good thing. But I'm like, Mike, some people are concerned, some married people are concerned that if the first spouse dies and they leave their part of everything to the surviving spouse, now the surviving spouse owns it all. And the surviving spouse could intentionally or unintentionally make a mistake and then leave nothing to the children. So that's the concern about, and we always have to have this conversation with the married people. And surprisingly, the feedback that I get is really open, and sometimes the spouses will talk back and forth with each other as to what they think is appropriate. And there's not a right or wrong here. So I'm like, Mike, you can just leave your part to Carol. Carol owns it all. And then if she doesn't change anything, then when she dies, it'll go to the kids the way we're talking about. But she could change it. She owns it all. Or option two, Mike, is you can leave your part in a trust for Carol. Maybe Carol would be the trustee of that Mike trust after Mike dies. And maybe Carol could take distributions from that Mike trust. Carol's still going to have her own $2.5 million to do whatever she wants to with. But when Mike dies with 2.5, it's going to go into the Mike trust. Carol could be the trustee. She doesn't have to be the trustee, but she could. And then she could take distributions from the Mike trust as she needs them for her, let's call it health, education, maintenance, and support. And then when Carol later dies, what's left in the Mike trust automatically reverts back to Mike's heirs. Carol can't change where the Mike trust is going to go after Mike dies. It's locked in when Mike dies. So there's more options, but for purposes of our live stream, I just gave that couple two options: leave it all to the spouse, and hope that the surviving spouse ultimately honors everybody's wishes and leaves it to the kids when the surviving spouse passes away. In many cases they do, in some cases they don't. Or does the first spouse to die want to leave their portion to a trust, which has more protection for the children to get it when the surviving spouse passes away? So if you're a married couple going to an attorney to discuss some estate planning, you better expect to be asked. You may even want to have the conversation in advance. How do you want to leave things to each other? All right, so we got that covered. So now, in general, we've got what happens when the first spouse dies, what happens when the surviving spouse dies, who's going to inherit outright or in trust, who's going to be in charge of overseeing that settlement. Now we got to get into as I started at the end and worked my way back. Now we're going to talk about you're alive and you can't handle your money. So most people pretty open to having that conversation. So, the question that you might get asked is, again, if we're talking to a married couple, I'll make some assumptions and ask the people to correct me if my assumptions are wrong. But if Mike and Carol are sitting in front of me, I might say something like, now we got to talk about if you're alive and you can't handle your money, you can't sign your name. Who do you want to make it easy to be able to do that stuff for you? And I might even say most married couples say they want their spouse first, and then perhaps maybe one of the adult children is the backup. And then here we go with the questions. Can we have two? Can we have all of our children? Similar type conversations. There's nothing that says you can't have two or three that have to work together, or four or five. Nothing says you can't do that. But many of the financial institutions out there, they won't honor it if they have to work with more than one. So then you've got to go through a bunch of paperwork, and some of those people have to resign so that it leaves one. And or if you name two, set it up so that either one can do things for you instead of both of them having to do it jointly. So a lot of those conversations and those durable power of attorney conversations that we have. So yes, that's the question. If at some point during the rest of your lifetime, if you can't sign your name, illness, injury, or otherwise, who do you want to make it easy to be able to do that for you? If you're married, most people say their spouse first, maybe an adult child is the backup. If you don't have an adult child, it is a good idea to name a backup, because your spouse might not be available to do things for you if you get to a point where you can't handle things for yourself. So then you're maybe going to other family members, siblings, nieces or nephews. If either you don't have adult children, maybe your children are minors, or maybe you don't have children, then again, always good to name a backup. And then there's who do you want being able to go get your medical records, talk to your doctors about treatment decisions? Who do you want to make it easy to be able to do that? If you're in a condition where you can't make your own medical decisions, most married people say that I want my spouse first. If my spouse can't do it, then I want this person or these people. had a couple Friday. They said, yeah, we want our spouse first. We have 3 daughters. And if I can't make my medical decisions and my spouse isn't available to make them for me, any of my 3 daughters, I want to, I don't know where they'll be. Some of them might be near us, and some of them may be very far away from us geographically. So we want to make it easy. We realize medical decisions need to be made quickly sometimes. We know that our daughters will consult with their sisters. So let's say spouse first, and then any of the 3 would be authorized if the spouse isn't available. So there's some of that medical questions that you can expect to get answered. In addition, there's the whole life support machines decision. Do you want to make your wishes known, keep your family out of that decision? Because you can state your wishes and direct your family and physicians honor your wishes. And sometimes those living will decisions are documented so that if you are in that profound vegetative state, no chance of recovery, machine serving only to artificially prolong the dying process. By signing the healthcare documents the right way, you're relieving perhaps your children from having to make that burdensome decision to terminate life when you're in that vegetative state and the doctors have determined there's no chance of recovery. So some people want to document those wishes, relieve their children or loved ones from having to make those decisions. So that's another thing that's typically discussed in the estate planning conversation. Okay, so we've gone through fairly quickly who inherits from you, how to leave things to your spouse, who handles it when you die. If you're alive, can't handle your money, can't handle medical stuff, life support machine stuff. We've talked through all of that. And we talked through it fairly quickly. And in fact, usually doesn't go this fast. Then it's on to some of the kind of substantive or technical questions, at least in my mind it is. And in my mind, I'm thinking, okay, now it's time that this couple has done a fantastic job answering all of my questions. They know who they want to inherit. They know whether it's going to go outright or in trust. They're comfortable about how they're leaving things to each other. They designated all the right people to handle this when they die, when they're incapable. Now let's talk about the form of how we're going to do all this. And in my mind, I'm thinking, okay, now it's time to have that will or trust plan conversation. And so that's another decision you need to make if you're a single person or a married couple is, do you want to do all this through your, what I call your will plan, where for a couple, we set up each of their wills. Mike and Carol. Mike's will says, if I pass away, I leave my estate to Carol this way. But if Carol dies before me, I leave my estate to my children this way. And I name so-and-so as the executor, Carol first, so-and-so as the backup. You leave everything in your name, and then we create all those powers of attorney. There's 2 ways to do all of this. One is through a will plan. One is through a trust plan. And so do you want to do it with the will plan and what some people perceive as a negative of the will plan? Simple to set up. Leave everything in your name. But when you pass away, assets in your name, or at least some of the assets in your name, you likely have some non-probate assets that will go to designated beneficiaries, things like IRAs, life insurance. But you may also have other assets that, if they're in your name, when you pass away, even if you have a will directing where they go, there will be a probate required, and there'll be lawyer and court involvement. Some people perceive that as kind of a pain, because often it is. There's an expense, there's a delay. And so the second way to set all this up, I might tell Mike and Carol, is to set up the Mike and Carol Revocable Living Trust. And then the idea there is transfer all those assets, like your home and your brokerage account and your business, from Mike and Carol to Mike and Carol as trustees of the Mike and Carol Trust. Because things that are titled in the name of your trust when you pass away, they don't have to go through the lawyer and court involvement. So if Mike dies, Carol stays in control of everything. Kind of depends on how Mike set it up. But then when Carol dies, that successor trustee that you told me you wanted to handle things after both of you pass away can step in immediately, sell the house the next day, go deal with the brokerage accounts once they get your death certificates, and start dividing that up appropriately in accordance with the terms of the trust. So the trust really replaces the will. And the idea, if you already have assets titled in the name of your trust when you pass away, things that are in a trust don't have to go through that court and attorney involved probate process. So you can either, that's the question that attorneys should be asking you, do you want to leave things in your name, create that will plan, realizing that there's likely to be probate when you pass away, or do you want to create that living trust and create a scenario where when one of you dies, if everything's set up correctly, there isn't that probate. When both of you pass away, that successor trustee can do what they need to do outside of those court and lawyer involved probate proceedings. So I think around the country, and I know, I think maybe 95% wind up going the trust route. A few percent will go the will route. Typically, the will route is less legal expense now, perhaps considerably more legal expense when you pass away, where that living trust expense to set up is typically something more than the will expense, but that can eliminate the settlement and probate expense when you pass away. So there should be some kind of conversation that you'll have with an attorney about that. And they should perhaps even kind of give you some numbers so you can weigh those decisions in your mind and make an informed decision. And so maybe you're saying after you have that conversation, yeah, we really like the idea of that trust plan. My parents had a trust. If things went really smooth, or maybe my mother died 3 years ago. She had a will. We had to go through the probate. Wasn't that bad. It seemed to take a long time, and there was a bunch of paperwork. But whatever, people make decisions based on their life experiences. So maybe they'll say, yeah, we think we like the trust plan, and maybe there's some conversations about legal expense and all that as part of that conversation. And then real important for the attorney to ask you, you may remember early in the live stream, I kind of put it on you to tell the attorney or whoever it is that's guiding you through this, that you need to tell them some of the, if you have specific concerns that you want to make sure get addressed, it's kind of on you, ideally early on in the conversation, to say, Mr. So-and-so, Miss So-and-so, Paul, whoever, here, let me tell you why I'm here. I'm here because whatever. And so really important that you communicate that. I think that the better attorneys will pull that out of you. And so let's say, for example, you didn't communicate something early on, or you didn't even think of it until you got a little further in the conversation. That can happen too, because the lawyer is going to bring up things that you haven't really thought about. And now that the lawyer brings these things up and asks you questions, it triggers maybe things that you weren't thinking about before you started having the conversation. So really at that point, maybe the lawyer's kind of asked most, if not all, of the questions he's going to ask. And based on the answers that you gave, it may have caused many, many, many more questions, and that's okay. But at the end, the lawyer should ask you, hey, Mike and Carol, is there anything that I haven't asked you about yet that you wanted to make sure got covered in this important conversation about, how your things are going to be handled, not only for the rest of your lifetime, but also, when you pass away, for your family, because this is really important. So that's where, the good lawyers will try to pull out, that deep concern that you have. And maybe Michael say, well, now that you ask, Paul, I am kind of worried about this, and who knows what this might be. My daughter's marriage is on the rocks. My grandchildren, I think, has a substance abuse problem. And maybe it just wasn't something that either the person thought about or wasn't comfortable discussing very early in the conversation. But now that they've seen how important this is, and they're making these decisions, now they're realizing, I better tell this lawyer about this issue, because I need to feel good that this issue is being resolved. So really towards the end, after a lot of the questions, you ought to get a question. Is there anything we didn't talk about that you wanted to make sure we did talk about as part of getting everything in order? And maybe you'll have something, and maybe you'll say, no, boy, you asked me a lot of questions, and some of which I didn't even know we were going to talk about, but I don't have anything else. No, what you covered, sounds great. So then maybe the last question, especially if the terms of the engagement were discussed, legal fees, timing, all that stuff, which maybe should have been discussed a few minutes earlier. Really, the final question is, do you want to get started? So again, that question is just, in other words, it's like, okay, the attorney has done his or her best to enable you to make these really important decisions, and hopefully the attorney kind of gave you some pros and cons of answering certain questions a different way, and not only gave you options, but also maybe said, well, if you choose this option, then you also need to know that this will occur, and if you choose this option, then perhaps you need to know that this will occur. Kind of like if you leave everything to your spouse, then it's all going to get a step up in basis for tax purposes when the surviving spouse passes away. That probably wasn't going through the couple's mind when they were trying to figure out, is my surviving spouse going to remarry and leave all my money to their next spouse? But it's enough of an important factor that can factor into the decision. So anyway, that's all part of the estate planning discussion. And then, if they say yes, if you say, you're asked that question, do you want to get started? You say yes, then there's just every lawyer will have their process for additional information gathering and kind of the detailed stuff that people need to know, name spellings, a few details involving answers to questions. But and then, so what I want to do next, I want to do a little case study here. If some of you have listened to my live streams in the past, I use Fred and Wilma Flintstone, and I've kind of probably overused old Fred and Wilma Flintstone because it's almost too simple. Fred and Wilma, I think, had one child, Pebbles. Something about Bam Bam. I don't know. I gotta figure that out. But anyway, I thought I'd use a case study for purposes of this live stream and use one that was a little more complicated. If you're about my age, I'm 58 years old, I would think you certainly remember the old Brady Bunch. I was doing a little research for this, and some of those characters in their own personal lives have had their share of challenges. But forget all that for now. Let's say we're going through the case study of Mike Brady and Carol Brady. If you're the one person on the planet who doesn't know who the Brady Bunch is, now there's more than one person on the planet. If you're maybe really old or you're really young, you don't know who the Brady Bunch was, but there was a sitcom that I would watch every day, or just about every day when I came from school. It was Mike Brady was the husband. He had 3 boys, Greg, Peter, and Bobby. Carol Brady was the wife. She had 3 daughters, Marcia, Jan, and Cindy. And apparently they, Mike and Carol married, and they each brought their 3 children. And so that was the blended family. They had the little housekeeper, Alice. We may talk about Alice. Maybe they want to do something for Alice. So now let's go through, in that blended family situation, how would Mike and Carol have answered these questions? So we would have gotten the family tree. I don't know if Mike's first wife died or whether he got divorced. I don't know if Carol's first husband died or whether she got divorced. Maybe it was in one of the stories. You can let us know if it is. But so we'd ask about the family tree, and Mike would say, yeah, I have 3 boys. And then I met Carol. Carol has her 3 daughters. We got married, and now there's 6 kids. And again, we want to know what you own. They seem to live in a pretty nice house. And it seemed to be over in California because there was some references to the Dodgers in episodes. There were some references to Hollywood. So, and so let's say they had a, $5 million estate. I think Mike was it seemed like it'd be a busy architect or something like that. So then the question becomes, all right, Mike and Carol, let's say you both pass away, even though it's not likely to happen this way. This helps us get where we want to go. If you both did happen to pass away at the same time, how do you want to inherit? And they might say, we want to leave everything to the 6 children equally. They might say Mike's things go to Mike's 3 boys. Carol's things go to Carol's 3 girls, which is not necessarily the same thing as leaving everything 6 ways equally. So as the attorney, I've got to ask them some what if questions. Maybe, Mike, your estate is larger than Carol. You brought some things into the marriage, or maybe, Mike, this house is yours. It's not Carol's. And so do you really want to leave everything 6 ways equally? Or is Mike's part going to Mike's 3 and Carol's part going to Carol's 3 because your estates are not equal in value? So we'd have to work through some of that stuff. There's more to it than that in the blended family. So we'd have to just work through those blended family issues and figure out how they want things to go. Maybe they want to leave something to Alice. I could see Carol saying something like, boy, since Alice was around, I never had to cook. And so I want to make sure after we both pass away, if Alice is around, I want to give her $100,000. So who knows? And then, leave the rest to our children. And then there's that, do you want to leave it to them outright or in a trust? And it looks like most of those kids in their real lives have been divorced, some of them several times. So and plus, since Mike and Carol were likely divorced from their first spouses, I guess I could definitely see Mike and Carol saying, boy, we want to leave it to our kids in a way that if they get divorced, they don't lose any of it. Let's leave it in a trust for them. And then there'd be some discussions as to when those kids could be the trustee of their own trust versus, when and who would be the trustee of the trust for the children after Mike and Carol die, up until the time that they can be their own trustee. So lots of conversation. We'd probably spend a lot of time talking about that, how the kids would inherit given a blended family, and given that Mike and Carol both either, I guess, were divorced. All right, then we'd ask, Mike and Carol, okay, after you both pass away, who do you want to handle these things? And Mike might say, well, if I pass away before Carol, I want Carol handling things. But when Carol later passes away, I want my stuff to be handled by Greg to make sure it goes equally for our 3 children. Carol might say, well, same with me. If I pass away before Mike, I want my things in a trust for Mike. But then when Mike later dies, I want my things handled by Marcia, my oldest daughter, to go to our 3 children equally. So, and then there's power of attorney conversations. And my guess is Mike and Carol would both say, yeah, if during my lifetime, I'm not able to sign my name, deal with my money, make my medical decisions, Mike would probably say, I want to make it easy for Carol to be able to do that for me. But if Carol's not around, I want maybe one or more of my kids to be able to do that stuff. Carol would probably say the same thing. So first marriage, one set of kids from one marriage, that couple's likely to 99% of the time, they're going to agree on who handles the stuff when they're incapable or when they pass away. But that blended family, it's often each spouse has their own set of people who would handle things either when that spouse dies or when that spouse becomes incapable. So it gets a little more complicated with the Brady bunch or with the Mike and Carol, who each brought 3 children into the marriage. Okay, and then we'd have some of those life support machine discussions. What we'd probably do, since probably Mike wants his things to go to his 3 boys and Carol wants her things to go to her 3 girls, we may set up a trust for Mike and a trust for Carol. Maybe they each have their own trust, the Mike trust and the Carol trust, but maybe they have a bunch of assets together. This is just a style thing. It doesn't have anything to do with taxes or who inherits. It can be done either way. Maybe there's the Mike and Carol joint trust because they have a whole bunch of joint assets together. And it's okay, even if Mike wants his things to go to his 3 and Carol wants her things to go to her 3 daughters, that can all be done through the joint Mike and Carol trust. So there's a decision, mainly falls on the attorney. It's more of an attorney decision. In this blended family scenario, do we create separate trusts for each spouse? California is in a community property state. I don't know if Mike and Carol did a prenup. If they did a prenup, we'd probably have 2 separate trusts because what Mike owned was Mike's, what Carol owned was Carol's. They had no community property. And so that seems to call out for separate trusts for each of them. Put Mike's things in the Mike trust, put Carol's things in the Carol trust. Maybe they didn't have a prenup. They had a bunch of community property. and again, it's up to that attorney to really stylistically figure out whether they'll have a joint trust or separate trust. And so by that time, we would ask them, is there anything on your mind that we didn't address? And maybe Carol says something like, well, Mr. Rabelais, we have this iconic green and white sofa in our living room. How do we provide for that? And so little joke about their little obnoxious green and white sofa that they have in the living room. But sometimes people will say, hey, I've got this antique car, or I've got this jewelry, or, how do we do that? And so then there needs to be a conversation about what's the best way to handle those kind of tangible personal property items, those non-titled personal items. And there's a couple of different ways to do that. So we'd have a conversation about that if they bring that up, or if the attorney brings it up and there's that's something that's really important to me. And it is important. Sometimes it is the most important item that a person may have, is how those non-titled personal items will go. And then, we'd get started gathering information if they were ready to get going and start. The attorney would get started, gather the information, prepare the trust, the wills, the power of attorney, the transfer documents, the healthcare documents, all in accordance with their wishes. There'd be some kind of review, get it all signed, witness, notarized. Again, if it was one of our clients, we'd upload all their documents and their information to their online vault account that they'll have forever. So with that in mind, as I move over to the chat here, I'd probably be remiss if I didn't at least offer this. I'm going to do it quickly in about 10 seconds. If some of you out there, I'm the founder from several years ago, created a national estate planning law firm. If you're like, boy, those conversations that he said I would be asked, I'd like him to ask me those questions, or I'd like Paul to ask us, me and my spouse, those questions, because we need to get all of this in order. You can go to the link in the description of the YouTube video and request a Zoom meeting with me. And if everything works out, we'll have a Zoom meeting. We'll talk through. I'll ask you all those questions, and then if appropriate, we'll help you get it all in place. So with that, moving over to the chat. Good to see all the people that were here early. You're welcome, Susie. Susie Aspen, who's not from Aspen. I think you're from somewhere else. You were from Aspen. I think you told me one time. Larry just noticed, said, Joe, where did that come from? Larry, you might be slipping a little bit. I don't think you are. You're sharp. You're early every time. That means you're sharp. So good. That's okay. People have called me worse things than Joe. All right. Hey, Brenda and Shane. Autocorrect. That's probably what it was. All right. Okay. Aaron, 6:30 Central. Christy, hi. My parents are interested in creating a estate plan to benefit my son, maybe. It says SO, who has Down syndrome. Okay. We have to set up, and just recently, and we're interested in hear about next step. We have set up a special. Okay. So you set up a trust, special needs trust, maybe, and your parents want to create an estate plan to benefit your son. So yeah, there's, we didn't get into the specifics of special needs trust. Real quick, often children with special needs, they're getting certain government benefits. If they inherit assets in their own name, those government benefits could be jeopardized. Government says you can leave their inheritance to a special needs trust that's designed to supplement what the government provides for them, and that way they don't lose those government benefits. So that's what we're getting at there. Luann, your videos are so helpful. Very nice. Very nice of you to say that, Luann. Lacey, so helpful. Also from Maryland. Hey, good. I'm glad you are. Maryland's a great state. Bradley, the internet most famous. You guys are just making my day. As good at what it does, and because he enjoys it. Yep, I do enjoy it. Thanks, Bradley. Aaron, do you have a book or workbook to outline these steps to prepare to speak to an estate attorney, or recommend to plan ahead if we have another 25 years? I don't have a book. I wrote a book a long time ago for my state. Now we do stuff nationally. It's high on my list to write a book, but I don't have it. Hello, I'll have to watch this later. Arthur, can IRA money or gold be placed in an irrevocable trust? I already have an irrevocable trust, 4 years so far for my home. You can't transfer, and I'm reading through the lines here, Arthur. When you put the 4 years so far, you're probably meaning 4 years into the 5-year look back period for potential long-term care Medicaid qualification. You can't put an IRA just direct from your name into a trust. An IRA while you're alive, an IRA has to be in your individual name. Some people ask me how, I have $400,000 in my IRA. I live in a state where the IRA is a countable resource, as most states provide. How can I get that into out of my name so that if I do go into a nursing home, that won't be a countable resource and I won't be penalized for having it? So IRAs are tricky. For many people, they have, if they want to get it out of their name, they've got to take it out of the IRA, pay the income tax, and then take those after-tax proceeds and put them in a trust. Same thing with a Roth IRA. Can't transfer a Roth IRA to a trust. Take the money out of the Roth. That's a bummer. And so many people, they don't want to do that, and I don't blame them. So that's just another conversation. Good. You have one son, responsible and not married. Fantastic. Hey, Susie Fick from Illinois. CZ, can you please ballpark amount for the cost of shut up? All right. So there's two questions there. First, let me address the second one. CZ, what state am I in? I think what you're asking, because most people, when they ask that question and I ask them to elaborate on it, they just want to know if I can help them. But to answer your question, I'm in Louisiana. I'm licensed in Louisiana. But a few years ago, because of my YouTube presence, tens of millions of views, people asking me from all over the country, Paul, can you help me set up a national estate planning law firm? Everything, you typically starts, with me. We have the conversation. My office gets everything prepared. We get a lawyer in your state. If somebody on our staff is not licensed, we have our co-counsel arrangements in all of the other states. They participate as well by reviewing, giving their input, and before everything gets made official and signed. So the answer is we can help you. And there's a method by which we do that, where we get a lawyer in your state to participate. That's our co-counsel. Now, ballpark amount for the cost of having a trust set up. On our website, we have this kind of range, and the range says, $4,500 to $6,500 plus. Most people fall in the lower part of that range. But as you might imagine, we get all kinds of requests with all kinds of different circumstances, with all kinds of different assets, with all kinds of different requests. So we have to ask all of those questions that we asked you in this live stream before we can accurately determine what's appropriate and what's reasonable from a legal expense standpoint. If you live outside the states but have a U.S. estate, what to do and how effective can it be? If you live outside the states, you can still create an estate plan. Now, if you own land in a foreign country, then you're going to have to deal with the laws and rules of that foreign country to deal with the disposition of those assets that are in a foreign country. We just have to talk and see what your circumstances are. LJ says, hit the like button. Couldn't agree with you more. That would be fantastic. Subscribe. I think you have to be a subscriber to ask a question anyway. Whiskey Business, good. Another familiar name. You can watch it later. Fantastic. Maria 28. Only concern. Yeah. Good answer. I'm glad you addressed that, Maria. U.S. estate only concerns property and or assets in the USA. Good. There you go. That's consistent with what I mentioned. Can you put a 401k in a trust? You can't. 401k, as long as you're the owner, you can't just transfer that to a trust. It has to be in your name. There's a whole nother discussion about perhaps naming a beneficiary, naming a trust as a beneficiary of a 401k. We'll deal with that a week from now on that what happens to IRAs at death live stream that I'll have. But if you're asking if an IRA owner can just retitle that IRA or 401k, the answer is no. Maria, now there's a conversation to Maria. That's good. Y'all can chat. John, 20 years ago, I bought a property from that today is worth $300. Can I take out the appreciated value to pay off the remaining principal of the house? Can I take out the appreciated value of the property to pay off the remaining principal of the house? I don't know what can I take out the appreciated value of the property means. Does that mean you want to take out a home equity line of credit, for example, for whatever the mortgage is and pay off the mortgage, the original mortgage, but then you've got the home equity line of credit debt? I don't get what you're asking there. So would just need more. Maria, good answer there on the international stuff. Paul, I can imagine how Shane prepared a YouTube of your channel when speaking with good, fantastic. Brady Bunch, good. Raider Girl, love your analogy. Great. Brown Eyes, do you think? Thank you, sir. Yeah, we can handle people in California. We recently redid our wills, have powers of attorney, but we know there is more. Could we use what's in place and then build from there? Possibly. Just depends what's there. Some people, sounds like you, and so you're common. You're like, boy, we did some stuff recently, and we don't want that to go to waste. We paid money to get what we did recently, but now we need to do more. We don't want what we did to go to waste. Can we just supplement that? That's a tough one. So it just depends what you have and what you're trying to accomplish. Let's see, Aaron, if you stop in 10 years from now, your lifestyle is different. Marion, can you just upgrade? Yeah, you can. So for example, when we create these living trusts for people, if their circumstances change, we'll either do an amendment to their trust or restatement to their trust, but they don't have to start over. They don't have to title things differently. They can keep things titled in the name of their trust. We just restate the terms of the trust, which is easier than starting all over. Let's see. Flower, Temple Effect, Temple Elect. What if our children were stolen and power of attorney abuse what if there's an IRA account under payable on death to me, the only child laundered? So yeah, that's big problems there. So there's a lot of background on that I'm just not going to touch because I just have to be guessing on a lot of stuff, but sounds like a real sticky situation. All right, that was my view. This was really good activity in the chat. It was, I like the topic because it just enables you and hopefully gives you some comfort about what kind of conversations you can expect to have. Whole idea is to get more people comfortable with estate planning, regardless of who you get to help you and when you do it. Hopefully the earlier, the better. Hopefully you can do what you need to do to get that peace of mind and know that things are in order. And then hopefully things do go well exactly how you'd want. So, all right, y'all have a great night. Thanks, everybody. We'll see you next time. Check the community tab. Y'all have a good one. See you.